Hi, I'm Greg Dell, and I'm here with Steve and Jessup, and we're going to talk about Prudential disability insurance claims. Now, Steve, in preparing for this video today, I was thinking about, what types of examples of cases we want to talk about. I know we're doing an overview video of our experience with Prudential, but there's so many cases that come to mind in dealing with Prudential over the last 15 to 20 years. Cases in Hawaii, North Carolina, Oklahoma, California, Florida, all over the country because our clients are everywhere. And, the experiences have been just such poor denials from Prudential. And my opinion as to the reason why that happens is because you're dealing with a gigantic company, one of the top 5 largest disability insurance companies, and you have a lot of employee turnover. And because of that, I think you get poor training of the employees, which then goes to poor quality of their denial letters and all the other communications that come from them. But what's your experience been like in dealing with them, at least once you get a denial letter from Prudential Insurance Company?
The experience there, to me, the way I see it is more so probably than any other insurance company. Prudential is about the business of insurance. It seems that everything is done with this idea of the bottom line. It's not really the person. They're looking at a claimant and a claim number and what do we need to do to meet minimum thresholds. And yes, some of our policy language has been challenged, but we haven't taken enough hits to want to change it and type stuff. So it seems like it's just a massive factory where they're just turning the cases out. They're reviewing it the least that they have to initially, especially. They may not be getting doctors involved until the appeal levels and stuff. And it just seems you hear more and more from people when they contact us is, they said they didn't get any information. I sent it. I watched my doctor send it. I have the fax confirmation. Or we discussed something and then they forgot that we had already talked about that. So I think that goes with, you said, the turnover, and maybe people are so inundated with claims. So it just seems like there's no real level of certainty that an insured has when they're trying to deal with it. This is so important to them. They're not working, they're sick, they're going through this, but you hear them talk about how they're dealing with a company that seems to not care at all.
Yeah, I would say you made a good analogy, like it's all about business and they're big. It's kind of like the difference between like going to a chain restaurant. It'd be like going to McDonald's versus going to like a local restaurant that has an amazing burger, that has catered service and better high-end meat and everything. You're just dealing with a volume player, and that's basically what Prudential is. And the other thing with that is that they sell their insurance for basically dirt cheap compared to what you would get from another disability carrier. Now, with that Prudential cheapness that we're talking about, or lack of quality, let's transition right into their definitions of disability, because that's what this is all about. What do you have in your policy? What terms did you get? So what do you usually see as the definition of disability in a Prudential disability policy?
Well, depending on how the employer wanted to pay premiums, you have an option of a 12-month or a 24-month own occupation, where generally it's something along the lines, are you unable to perform the material and substantial duties of your regular occupation? Then after that mark, this idea of any occupation based upon training, education, and experience. Making even more so, their policies are written that when they're talking about your own occupation, you would think that, okay, the job I'm doing, but it's actually based on the national economy, how your job is performed generically anywhere, not for how you did it for your employer or for a specific location. So it's the most base level of it. So the policies, that's just kind of the context you're going to look at it is, is your coverage really as strong as you think it is, or unfortunately even as strong as your HR may have told you, oh, we have this great benefit that we can give to you if you want to enroll in it.
Yeah, the only thing is on the any occupation, which is somewhat beneficial, is they usually have what's called any gainful occupation, which means you have to be unable to do any job that would pay you 60% of what your pre-disability earnings were, which some companies write it as any gainful occupation with no income component whatsoever. So basically they'd say, like, if you could flip burgers, to go back to the burger analogy, then you would be able to work. But if you were earning $100,000 beforehand, then they're going to say you got to be able to do a job that would pay you $60,000.
And for most people, it's actually what their disability benefit is, 60%. It'd be a job that at least pay you that amount.
All right, so let's talk about Prudential's claim forms, because there's some things that I find interesting. At the start, I find them to be very superficial, very narrow in the scope of information that they ask for, meaning like, what's your disability? They'll give you one line to fill it in. Can you sit, stand, or walk? Lift above shoulder, bend, lift, all those different things, very limiting, and then the same forms that go to the doctor. But then later on, that like 8 or 9 page activities of daily living form.
Prudential has the most forms, most variations of their forms, and it's just the most incessant request for forms, hands down. Prudential does have the most in-depth, and they get very specific. Sometimes even you'll see if the person, your client was a doctor, or a lawyer, specific forms just to that occupation. So Prudential loves their forms more than anyone.
Yeah, and then they'll also, if you have a mental nervous type claim, like a psychiatric condition, they have a behavioral health form that's multiple pages as well. And I think these forms are good and bad. They're good if your doctors really take them seriously and fill them out, but many doctors don't want to be bothered with this, and they know that, so they overwhelm the doctor, and then the doctor doesn't provide enough information, and that's a big, that's a big concern. And then for the claimants filling it out, you don't want to get lazy in filling those forms out, but you also want to be very truthful in how you're answering those forms, because they'll then try to get you under video surveillance and try to say, by asking so many questions, they're looking for some nugget to be able to say, well, we got you on tape driving longer than the 30 minutes that you said you could drive, or going to the grocery store. I mean, they ask a lot of questions in there, and the whole point is it's all a setup. So you need to be very cautious in how you're filling out, those forms, whether it's your initial application or if you're on claim. Let's transition to Prudential's common strategy on the appeal. They have the opportunity to examine a claimant, use outside doctors. What techniques do you see that Prudential uses when reviewing a disability denial on appeal?
On appeal, from my personal experience, the level that they will put into that review, I find has direct correlation to the amount of the monthly benefit. Clients I've had that have a larger monthly benefit, I've seen multiple independent medical evaluations performed, whereas someone who doesn't, they'll just send it out to, they'll hire a third-party vendor who will hire a doctor to do a simple review. So they will, do different things with that. Again, I think it goes back to the business. The ones that could be higher paying, higher risk, they're going to set themselves up for long-term success from a business standpoint. The ones that are lower value, I think they're like, why would we invest the money, same amount of money in reviewing this? Let's do the bare minimum on it. And then also you have to do with it, their policies can also differ in their limitations. Sometimes just a 24-month limitation for mental health, but now they're starting to write more limitations for a lot of physical conditions. Again, this goes back to the premiums. You said the premiums can be very cheap. When the employer is selecting which policies, the more restrictions are, the cheaper the premiums are. So it's really, for them, to me, it's always this idea of where's the business in it for them to maximize, their profits.
I do find that they will tend to do more IMEs than particular other companies. They'll work with these third-party companies that will find an IME doctor, but even though they're using a third-party company, these are still what I think are hired gun doctors that are doing a lot of the insurance company reviews, and I find the quality of the reviews, look, Prudential goes out and tells the third-party company, we're only going to pay like $1,500 for a review. So if you don't get doctors that aren't going to charge us $1,500, and the good ones are $3,500 or $4,000, then we don't want it. You also mentioned about you see that if the benefit amount's higher, that you think they do a different level of work. The reason for that is that through litigation, we've discovered that if your benefit is $7,500 or more, they have to go to a higher level director or vice president of the company to get authorization on anything they do. So the person who's evaluating your claim, who's signing that paper denying your claim or reviewing it, is really just a figurehead. There's someone above them that actually has the final decision-making authority who's deciding your claim. So that is definitely a known fact from our experience in terms of what's going on there. So the Prudential policies are interesting because when it comes to filing a lawsuit, most of them have a discretionary clause in them, which allows them to have this arbitrary and capricious review once a lawsuit's filed. But we've been able to argue in the past that they don't actually have that discretionary clause in the policy because of the fact that they put a statement on there that says this particular language is not part of the policy. So We've litigated that. It's a very technical issue that we can discuss with you in terms of how to possibly get to a de novo review. But talking about Prudential, why would it be important to get a de novo review when litigating against them?
So just so you know, when it comes to litigation, there's two standards: de novo, like you said, and arbitrary and capricious. As a default, most policies fall into arbitrary and capricious. Under that standard, as the plaintiff, you have to prove two things: one, that you're disabled, and then after that, that Prudential acted arbitrary and capricious. Which, to really kind of strip it down, it comes down to this idea: did they have a reasonable basis to deny the claim? So it creates a situation where the judge could find you're disabled, but think that the review was reasonable enough, and therefore uphold that decision. De novo, if you get there, and certain states have that as a matter of course, if you get there, the judge just has to go, is this person disabled? Obviously, if that was the standard of review throughout the country, I think you'd see a lot less denials, because I do believe a lot of judges feel for clients, because a lot of the times you don't read an opinion that, they don't think the person's disabled. It gets to the point that, I conducted, I think there was reasonable, and then there's the denial. So having a de novo standard of review really increases the, chances of a success in winning in court.
Yeah, I mean, with Prudential being huge, they're no stranger to litigation in the ERISA disability world. There's been tons and tons of opinions. Many of them are our own firm's opinions that have been issued, and Prudential's been slammed by courts. I mean, there's just outright district courts and appellate circuit courts that have just slammed them for their demeanor repeatedly. But you know what? It doesn't change anything at Prudential. They just keep going along doing what they're doing because they're still making money, their profits are up, and I don't even think they know how to implement the changes if they wanted to implement the changes, because they write such a high volume of policies. I mean, they have millions of policyholders. They'll take a company like Hilton that has 30,000 plus employees, and they'll write a group policy to them, and that one employer has 30,000 policyholders now through Prudential. So they're clearly overwhelmed, and they're just playing the volume game, and they're trying to get by and do what they have to evaluate the claim. That benefits the claimants, because when we get those claims, very often we can have great success in beating them up due to their terrible claim reviews. So no matter what stage you have with Prudential, and we've touched on it superficially, and I don't know if I mentioned that we have these other videos talking about appeals and talking about lawsuits, but if you're applying or you need an appeal or a lawsuit, what we'd suggest you do is give any of us a call initially. Then we're going to want you to send us a copy of your denial letter, which we'll review right away, or if you're applying, we'll review your application. We're going to give you a free initial review, and we're going to tell you right away what we think. We never charge any fees or costs unless we make a recovery for you, which is a great thing, so there's no risk there. Our initial review is free. We can help you anywhere you're at, and we really just want to have the opportunity to let you know what lays ahead for you and how we can help you to protect your benefits. So thank you for considering our law firm.